for those warm and heartfelt remarks. Now we move on to the formal part of the program where we are going to talk about patent law policy. And to start us off, we are very privileged to have the Honorable Paul Michel, as you heard from Dean Dickerson, retired Chief Judge from the Court of Appeals for the Federal Circuit, Chair of our Advisory Board, and I'll refer you to his bio in our programs for his outstanding accomplishments. I'll just mention two. He was one of the 7 judges appointed by the Chief Justice to serve on the U.S. Judicial Conference, the judiciary's governing body, as well as named as one of the 50 most influential leaders in IP in the world. The title of his keynote is The Arc of American Patent Law, also known as Balance and Rebalance Intellectual Property Policy. Judge Michel, please.
Good morning, everyone, and welcome to the John Marshall Law School Annual Conference. This is Judge Paul Michel, retired from the Federal Circuit, speaking, and I am going to provide initial remarks to try to set the stage for this extremely well-planned conference, which covers so much nationally and internationally. If my remarks were to have a title, I would suggest that the best title would be the following: Balance and Rebalance Intellectual Property Policy. Let's start with patents. Obviously, there are at least 4 areas of major difficulty with regard to patents, particularly in the United States. Number 1 problem is Section 101 on eligibility that is so unpredictable, difficult to apply, yields inconsistent results, and so forth. Number 2 is the problem of injunctions, which are now much more difficult to get, particularly for certain parties. Number 3 problem is the America Invents Act reviews at the newly expanded Patent Trial and Appeal Board, and the procedures and burdens and balances there that may, at least historically and to some extent presently, be unduly tilted against the patent owner and in favor of the challenger. Number 4, costs of litigation, not only in dollars, but in delay and uncertainty, in the disruption from massive discovery and so forth. Now, the important perspective is that the circumstances in commerce keep changing. The progress of science keeps evolving rapidly. And of course, case law also changes. But the need to continually adjust legal regimes to match commercial and scientific reality presents a great challenge, and in my view, it's not being well enough met, at least not in the United States. The changes are almost constant and continual, and they result in legal regimes, particularly court precedents, often lagging very far behind realities on the ground. Now, in the United States, for example, it is less clear than ever before whether a patent right is even a property right, or as termed in a Supreme Court case called Oil States, merely a public franchise, revocable by almost anybody for any reason at any time. So if, to the extent that view holds, a patent becomes little more than a piece of paper, not a right to exclude, but a right to file a lawsuit. Now, this raises questions about whether many patent owners can even afford to enforce the patents by prosecuting a lawsuit all the way to the finish. That can often take 5 to 8 years and $5 to $10 million. The outcomes can be very uncertain. The risk of invalidation is high, both at the Patent Trial and Appeal Board, and then later in the District Court or the Court of International Trade Commission, rather. Now, in the last century, there was what I would consider an honor system. So in the 90s, patent very little litigation. That was the norm. The norm today is quite different. Some people call it efficient infringement. But the reality is that it's now the standard practice of many large corporations to not voluntarily take a license, to wait to be sued, to fight the suit for the decade or so, and to take a license or pay up only at the end of that long process. With regard to injunctions that once gave the patent owner considerable leverage, that leverage is now largely gone because, as I mentioned, injunctions are now so much more difficult to get, particularly for non-manufacturing entities. So leverage has gone down, so has the value of patents on average in recent years because of legal changes, including the Patent Trial and Appeal Board, Supreme Court cases on eligibility, and related developments. Now, if we compare the patent regime to the trademark regime, I would suggest that trademarks work much better. The suits tend to be much faster, less costly, and finally decisive, very often settled on summary judgment. The result then is either a voluntary settlement at a very early date at a relatively low cost, or a quick injunction that then prompts a settlement. So that regime looks quite good. Copyright regime, in my view at least, maybe not quite as efficient and effective as the trademark regime, but still quite good and much better than the patent regime in terms of producing practical, beneficial results. There are, of course, some areas of substantial lack of clarity concerning the extent of the fair use doctrine and even copyrightability as exemplified by the current Oracle versus Google suit. Of course, the fourth IP regime is trade secrets. They're now federally enforceable as well as in state court. But in either forum, I expect that trade secrets may prove more illusory than real because the trade secret owner has to prove that it took reasonable precautions to protect the secrecy. And that's going to be difficult to do in an era where virtually all computers are hackable. Most have been hacked. And therefore it raises questions about whether if you put your trade secrets on even an internal company computer, are you taking adequate precautions or not? Now, all four IPR, that is intellectual property right regimes, are dynamic, not static. And we often forget that. They're constantly changing, both at the legal level and at the practical, commercial, and scientific level. So this raises a question, at least to me, with respect to the three branches of American government. So I'll leave out the executive branch for the moment, although, of course, that's where the Patent and Trademark Office resides. But the question is, what is the comparative advantage of Article III courts versus the Congress? What are the proper roles for each? And the same could be said, what's the proper role for the Patent and Trademark Office or related entities in the executive branch? Now, as a former judge, I'm very aware of the fact that court precedent is fixed and very difficult to change. In the Federal Circuit, there's a case called Newell, which says that any prior panel decision settles the law unless changed by Congress, the Supreme Court, or an in-bank decision of the Federal Circuit. As a practical matter, that means most panels in most cases are locked into precedent, and the precedent, of course, is backward-looking. It's slow to evolve to catch up with changing realities. It's typically out of date, obsolete, not wrong, but obsolete, or at least obsolescent. A couple examples. The troll narrative of the prior decade had some truth to it, but I would suggest was highly exaggerated by interested parties. But it was a second-order problem even then, and it's been replaced by a first-order problem, efficient infringement. There was a lot of talk in the prior decade about hold-up, the theory of hold-up, and it's obviously, in my view, been replaced by the reality of hold-out as the more typical and threatening problem. Now, contrary to the courts, the Congress is inherently forward-looking, not backward-looking. Statutes usually are effective only prospectively. The American Invents Act was passed in 2011, so we've had 9 years of experience under that regime with no adjustment. Meanwhile, we've had the 4 Supreme Court cases in the current decade after the AIA, and it revolutionized the law of eligibility. So it raises questions about whether Congress doesn't need to revisit the Patent Act and make adjustments in recognition of problems created by those eligibility cases. Similarly, the implementation of eBay, though a decision from 2007 in the prior decade, has been greatly affected by recent cases at the Federal Circuit in the current decade and also in the District Court with regard to U.S. PTO implementation of the 3 types of America Invents Act reviews, especially inter partes review. Huge developments in the era of 2014 to 2018. In the view of many, the procedures and burdens were stacked against the patent owner and needed adjustment. But Congress has not revisited those regimes created in 2011. The present PTO director has made some adjustments, some by regulation, like changing the claim construction standard from the so-called broadest reasonable construction to the court metric of correct or plain meaning construction. And on a more informal level, the director has tried to curtail some of the repetitiveness of challenges, often 2, 3, 4, 5 attacks on the same patent, even by the same party, not to mention others. Of course, informal policy set by the current PTO director can be changed by the next director, and it seems likely there will be a new director sometime perhaps in 2021. But whether by regulation or by informal guidance, the PTO director's hand is heavily stayed by the fact that many of the changes that might be needed can only be done by Congress. So, for example, the burden of proving invalidity, Congress set at a mere preponderance. In court, it requires clear and convincing evidence. But to change the AIA standard to the court standard would require changing the AIA, and therefore needs Congress. Same thing with regard to standing. Courts require standing before a party can challenge a patent. The Patent Office does not, because the AIA said so. And third, in court, there's a clear, strong presumption of validity of an issued patent, and that's less true, if it's true at all, in the Patent Trial and Appeal Board. Again, it would take congressional action. Injunctions and eligibility also require legislation to be adjusted, at least as a practical matter. In the 8 years since the Mayo case upended eligibility law, the Supreme Court has rejected something like 50 cert petitions asking it to revisit and revise the Mayo-Alice regime. It's turned down every single one. At the Federal Circuit, of course, their hands are tied by the Supreme Court cases and by their own panel precedents, many in number. With regard to injunction law, the Federal Circuit is also sort of trapped by eBay and its own prior precedents. So it is not in a position to make big adjustments. Therefore, once again, only Congress can make the big fixes. With regard to 101, efforts by many in the patent community to have eligibility reform were opposed in 2019 by certain companies, particularly big tech and big banks and some allies, and that reform effort stalled out. Similarly, the Stronger Patents Act, which addressed the problems with regard to injunctions and Patent Trial and Appeal Board IPR reviews, also was similarly stalled, and because of opposition from some of the same corporate interests. But it looks to me like the need for legislative adjustments is acute. If you compare it to tax law, the Congress revises the tax law practically practically every year, or at least every Congress. But here we are, essentially a decade later than the AIA, with no adjustment despite intervening developments of great consequence in the courts, not to mention in commerce and in the progress of science. Now, the leaders on these reform efforts, Senators Tillis and Coons, have just been reelected to terms in the Senate, so perhaps there'll be some more action in the ensuing period, but it's very difficult to predict. I want to also draw attention to what I mentioned briefly before, and that is, in the U.S., the cost of litigation is just enormous. It's almost impossible to get a grip on how difficult it is. Even in a case settled ultimately by summary judgment or partial summary judgment, the costs and delays and disruption occasioned by the vast discovery regime still extant in the U.S. are very high. And a case that has to go all the way through final judgment after a jury trial, of course, is vastly more expensive. And I mentioned some of the multi-million-dollar, multi-year figures earlier. Now, one of the consequences of these cost issues is that many patent owners actually cannot afford to realistically enforce their patents through district court litigation, or in the International Trade Commission for that matter. So have they become second-class patent owners? Are they forced to accept whatever royalty, if any, is voluntarily offered by an implementer? So patent litigation is sometimes referred to by wags as the sport of kings. It works okay for vastly wealthy companies like Apple to fight with Samsung, but for the average patent owner, for a startup, for a university, for a small or middle-sized or emerging company, it's a very daunting prospect to try to enforce a patent in court. And of course, that's going to almost always follow one or more petitions and a couple of years of delay and added costs in the Patent Trial and Appeal Board as AIA reviews wend their way through the process. Now, there's also a similar problem of whether we've created two classes of patent owners with regard to injunctions. Currently, a non-practicing entity almost never can get an injunction. Occasionally, a university can get one, but other non-practicing entities almost never get an injunction. Manufacturers, on the other hand, routinely get injunctions, readily get injunctions. So have we created a second-class citizen of smaller companies that don't manufacture products with regard to injunctions? And there are other questions that this conference and its vast array of very expert speakers will be addressing, I expect. One is whether the litigation of patents in Germany or England or even China is preferable to litigating in the U.S. because the results there are much faster, much cheaper, much more predictable, and more advantageous in other ways. So, for example, in Germany, an injunction after proving infringement is almost automatic. There are exceptions, and they're being expanded somewhat, as you will hear. But still, compared to the U.S., much more reliable that you can get an injunction if your patent is infringed. Same thing in China. Injunctions are routine, although damages have been lower, but they may soon rise. So a lot of questions about where's the better place, where's the best place to litigate. Maybe the U.S. has gone from, despite being a big market, the number one place to further down the list. Here's another big question the conference and all of you should consider, and that is whether our unitary patent system works well enough for all the different technological areas. Some people suggest that it should work differently for pharma companies than internet companies. But then the question is it even practical, feasible to balkanize the patent system according to different technological areas? And another question is, does the copyright system work as well for the useful arts as it does for the creative arts? And again, the Oracle versus Google case is an example of how that is playing out. Yet another question is whether any of the four intellectual property right regimes creates enough incentive to spur the innovation we need. For example, vaccines are generally not very profitable for companies, and so they tend not to undertake the research and the long development cycle needed. They get a lower priority. So might the U.S. need to find some way to work around that problem in order to have vaccines in advance and not trying to play catch up as we are now. Now, there's a lot of research and development money provided by the federal government, but the figures are clear that the private investment vastly outstrips the public investment, and the public fisc is running out of money because of corona, because of all kinds of problems. So the importance of private investment is huge and constantly growing. And then the final dimension I would offer to you is the reality of globalism. Commerce and science are global, they're evolving fast, they're becoming more global every year. Courts, as I mentioned, tend to be too slow to adjust to realities, particularly beyond U.S. borders. Few U.S. judges even really have a deep understanding of commerce, investment, or science. I want to suggest, too, that the main objective of intellectual property rights is actually not so much to incentivize creative people to create. As long as they can make some kind of a living, they will try to create the best they can. The more important function of intellectual property rights is to incentivize the usually huge investments that are needed, because these investments are highly risky, slow to mature, and very, very costly. So the incentives have to be high, or the money isn't going to be there. It will be invested instead in entertainment or hospitality or making movies or building casinos or something like that. So really the main targets of the intellectual property right regimes are venture capitalists and bankers. And of course, in other countries, companies can be subsidized massively by the government. China does a lot of that, as I understand. Here, almost no subsidization of private companies by the government. Therefore, once again, the private sources of capital become the critical factor. Now, there's also the competitive dimension. China has announced intention to surpass the United States in the 10 or so advanced technologies of the current century by 2025, only 4 years away. And what is the response of the U.S., or for that matter, England or Germany or Japan or other major markets and jurisdictions to that challenge? Now, it seems to me the U.S. Congress, like the courts, is too slow to act, not well understanding the real underlying dynamics. And to me, that suggests that the many speakers at this fine conference and peers elsewhere need to make more input in educational effort. Scholars, judges, and especially practitioners, and including investors and inventors, need to educate the Congress, educate the courts, educate other public actors, because right now they don't understand the link between intellectual property rights and investment incentives, at least not well enough. So this conference is a great start to focus those kind of issues and to try to help public authorities give us a more successful and efficacious intellectual property right regime. So thank you for your attention.
Thanks very much, Judge Michel. When you were talking about the global aspect of intellectual property, I immediately thought back to the two informal themes of this conference: interdependence and mutual understanding. And I think with all this rhetoric that we have read over the last few years, with what's going on, for example, between the US and China, we thought it was important to have people from China in unicorns, but people also intimately aware and understand what's going on in China, people like Judge Rader, to be able to give us perspectives on what's going on there. So that's going to be following from a patent session. But first, let me welcome Jean Quinn. Is Jean with us? Well, as Jean is coming on board, let me just say something about what somebody who is probably the very first internet celebrity in patent law. Gene is no stranger, I think, to most, if not all of you. He founded IP Watchdog, a platform which we are very grateful for really sharing the highlights of this annual conference, and have been doing that in partnership with Gene and IP Watchdog for several years now. Gene also teaches the PLI course patent here at John Marshall, and so we see him twice a year under normal circumstances. Hopefully, we will be able to resume that soon. So, Gene, over to you. I look forward to your discussion.
Great, thank you, Daryl. I appreciate the opportunity to be here at this conference with really an all-star panel, and I'm probably the weak link in this panel, so to speak. And so what I'd like to do is introduce the panelists, if I can. Judge Michel, who you've already met, who delivered the keynote, will be joining us as well in this conversation, which is patent law and policy views from the top. But joining us will be speakers from all over the world. We have Sir Christopher Floyd joining us, and he is Lord Justice of Appeal in the Court of Appeal of England and Wales. And we also have the Honorable Dr. Klaus Grabinski, and he was appointed as a judge in the Federal Court of Justice in Germany over a decade ago. And then we have Federal Circuit Judge Pauline Newman joining us again, and she was appointed by President Ronald Reagan quite some time ago, and continues to be a steadfast ally for patent rights. And another very good friend of mine who I haven't been able to see other than in this context for some time due to COVID is Kevin Noonan. And hopefully Kevin will help me kind of co-moderate this panel, because I bring sort of the software and EE knowledge here, and Kevin is the true expert in the biotech and pharmaceutical world. He is one of the original patent docs. I'm sure you all know him, and he teaches at John Marshall as well. So I'm happy to have all of you with us here today to have this conversation, and we're going to have sort of a free-flowing conversation. We've had a conversation to prepare for this. I took some notes about what Judge Michel discussed, which touched on a number of the topics that we said we wanted to talk about. So maybe we can start with some of those things. The one thing that he mentioned, he being Judge Michel, was this idea of holdout versus hold up, which brings up some of the eBay issues, which then also brings up the issue that he raised about whether you're better off litigating outside the U.S. rather than inside the U.S. nowadays. So that is a whole big question. Maybe we go around the panel and get people's thoughts on that, and anything else that you might want to lay some foundation for. Maybe we start with you, Lord Justice Floyd.
Thank you very much, and I'm delighted to be here in Chicago with not even a trace of jet lag. Thank you also very much to Judge Michel for his extremely interesting, wide-ranging review of the issues that are facing us in IP. Noted down more than a dozen of them, but on your specific question about hold out and hold up and eBay, we've recently had a very wide-ranging decision of our Supreme Court in the Unwired Planet case, where there's a whole range of issues, and I'm not going to take up my first mini slot by telling you about all of them, but most interestingly, right at the end of the judgment, once they'd got through a whole range of technical issues about FRAND licensing and the use of an injunction to compel a party to take a worldwide global license, there's a short section on a point which they didn't, no one took in any of the courts below, which was the straight one about the equitable discretion to grant or refuse an injunction. And the position of the implementers, the defendants, was that effectively once you have undertaken to a standard setting organization that your patent is open to licenses on FRAND terms, you have, as it were, changed the very nature of the right, so that the right is no longer, as Judge Michel put it, a right to exclude, but is simply a right to collect a royalty. And you are an SEP owner is no more than the owner of a right to damages. Well, the court resoundingly rejected that. They said that the undertaking that you give when you have a standard essential patent provides a defendant to a contractual provides him with a contractual right, which, like all contracts, has two sides to the bargain, and there is nothing in the IPR policy of the standard settings organization which says you can't obtain an injunction if the defendant doesn't keep to his side of the bargain. And what's particularly interesting is their discussion of eBay at the end of the case. Because having looked at the English cases on the discretion to award damages instead of an injunction, they looked at eBay. And the thing that they pulled out of that was the majority's view, headed by Justice Kennedy, that a patent could be used by a non-practicing entity to extort large royalties from infringers. And that was a reason why injunctions in favor of non-practicing entities should be, as I understand it from Judge Michel, have become extremely rare in the United States. Mm-hmm. But the Supreme Court in England has said that the non-practicing entity and the practicing entity are to be treated on exactly the same basis. And so far as the facts of the FRAND standard essential situation are concerned, there was, of course, no danger of the non-practicing entity extorting high royalties from implementers, because the only right that they have to extort royalties is a fair, reasonable, and non-discriminatory one. Mm. And so they've said that, of course, although there may be extreme cases where a non-practicing entity won't get an injunction, the standard essential field is not touched by the eBay doctrine at all. So that's that was my reaction to your question. I've spoken probably far too long already.
Okay, so and then Judge Grabinski, your holdout versus holdout question that seems to be one of the biggest issues going on in patent litigation right now, and from my perspective, driving a lot of where litigation is moving to.
Yes, let me first of all also thank you, particularly Professor Lim, for inviting me to this conference. It's a great pleasure being here. I heard a lot of people saying good morning. Actually, I'm not an early bird, so I'm quite happy to say good afternoon, everybody, from here. And I think I'm the only person on this panel who is coming from a civil law country. And let me just mention at the beginning of my little contribution that that we do not have the principle of equity, of law and equity in civil law countries. So already from a theoretical starting point, it's a rather different system. However, at the end, I think we end up with more or less the same considerations. But and so when you talk about eBay criteria, I think this translates to another word in Europe, at least in the civil law countries, and that's the word that's called proportionality. So what is discussed in the US as eBay criteria is proportionality in Europe. And we have now also a huge discussion in this regard. Well, proportionality you can find in all fields of law, but it is particular with regard to IP rights laid down in Article 3, paragraph 2 of the EU directive on the enforcement of IP rights. Directives do not directly apply, but they have to be observed by the national courts when applying national law. So proportionality is always an issue when brought forward by the lawyers in a litigation. Now, with regard to patents, I think, and with regard to injunctions in patent litigation, I think the principle of proportionality is discussed in 4 respects, and they sound similar to what you discussed under the heading eBay criteria. The one aspect is public interest. Another one is complex products. Another one is standard essential patents. And the 4th one, more theoretically at the moment, I have to say, is non-practicing entities. And let me just a little bit go a bit deeper with all these 4 aspects. The public aspect is essentially safeguarded by the possibility of obtaining a compulsory license in Germany by order of the Federal Patent Court, if necessary also in preliminary proceedings. It is required that the license seeker unsuccessfully try to obtain a license from the patent holder and that the public interest warrants the issuing of a compulsory license. According to the case law of the Federal Supreme Court, public interest is generally affirmed when a medicine for the treatment of severe diseases has therapeutic properties that the drugs available on the market do not have. So it should not be an equivalent a drug be available on the market. That could be a reason for issuing a compulsory license, or if it avoids undesired side effects that have to be taken into account in connection with other therapeutic agents. So that's about public interest in a nutshell. In cases in which the infringed patents concerns only a small part of a complex product, a use-by period may be available under very exceptional circumstances according to the case law of the Federal Supreme Court. There's one case that dealt with this, that's a heat exchanger case. A use-by period may be come into considerations when the disadvantages of injunctive relief for the infringer go significantly beyond the normal disadvantages of an injunction in a patent case. So essentially the test is you compare the normal disadvantages of an injunctive relief, and that has to be accepted since the court found there's a patent infringement. So there has to be something extra disadvantages. For example, one might think of a hold up situation. That could be a situation. Other criteria are also mentioned in this decision, but I do not want to elaborate on this. Let me turn to the 3rd regard. In cases of an infringement of a standard essential patent, injunctive relief is only available when the infringer turns out to be an unwilling licensee. So unwilling to take a license, in particular when he is trying to hold out the SEP owner. That could be the case, for example, when the license seeker is only pretending to be a license seeker, but the way how he acts in the negotiations shows that, in fact, he has no interest in really taking a license. There was a case where this turned out to be, that was recently decided by the Federal Supreme Court. That's the Siswell hire case. On the other hand, I have also to mention injunctive relief is not available when the SEP holder makes no offer for licensing the SEP, or the offer he makes turns out to be not friend. In that case, injunctive relief is off the table. Fourth group, with regard to non-practicing entities, in that regard, there is no case law, at least at the moment in Germany, in which a patent owner was denied injunctive relief after the court found that his patent has been infringed only because he is a non-practicing entity. So this seems to be quite different from what I learned from what Judge Michel said in his contribution. So now that's the state of play. So what might be in the future? Parts of industry, in particular the automotive industry, in the era of Internet of Things and 5G, demanded that the German legislator should tighten the conditions for issuing an injunction in patent infringement cases. Other parts of industry, however, were not in favor of such a change in the law. So we have a kind of different positions depending on what part of industry you look. In 2020, the Federal Ministry of Justice submitted several drafts for a revision of the German Patent Act, including a revision of the provision that is dealing with injunctive relief, which is section 139 of the German Patent Act. The last draft has still to find the approval of Parliament, but it has good prospect to become law. According to that last draft, injunctive relief shall be excluded when, due to the particular circumstances of the case, its enforcement would lead for the infringer or a third person to disproportionate disadvantages that are not justified by the exclusive right. There again, you have the word of proportionality, disproportionate. The wording of the draft essentially takes up a formulation from the heat exchanger decision of the Federal Supreme Court I already mentioned with regard to complex products. The Ministry of Justice gave some reasoning for its draft, and there it can be read that the revision of the Patent Act only intends to clarify what is already in the law with regard to section 139. However, it remains to be seen whether this clarification, as the ministry says, in the German Patent Act will restrict the availability of injunctive relief with regard to the principle of proportionality the same way as it did in the past, or whether it will become more difficult in the future to get injunctive relief in patent infringement cases. I think this essentially sums up the current situation in Germany. State of play.
Okay. Well, great. Thank you. So now it's interesting. You know, I'm in the middle right now ourselves at IP Watchdog doing a standard essential patent program. So I'm very familiar with the cases that you raised, Your Honor, Judge Grabinski, and Your Honor, Lord Floyd. Seeing action in the standard essential patent space is interesting, because for a very long time there was this feeling that you couldn't get any kind of injunction there because you had agreed to FRAND, and I think things are changing. And Your Honor, Judge Newman, I'd like to get your thoughts on this as well. I almost don't know how to phrase the question, because I'm hopeful, but I don't want to jinx myself, because it seems as if there is some realization now with the in December of 2019 in the U.S., the NIST, the USPTO, and DOJ said, shouldn't be a prohibition against injunctions in every case, because hold out can be as big a problem as hold up. And you need to look at the facts of the case, but that doesn't change the existence of eBay. So, I mean, I'm hopeful for the future, but I don't know where exactly that leaves us in the courts. Do you have thoughts, Judge Newman?
Yes, indeed. And this is, I'll come to the end of my thought to start with, and that is that yes, we see now that the same issues that we once thought were settled 2 centuries ago in terms of the patent incentive are all of a sudden in the forefront, evolving, uncertain, unpredictable. And we need to understand why. Well, I think that that's really not very complicated. It's because the technology, the science and the technology have changed. The evolution, the investment, the way business is done. And almost all of a sudden, the old rules take on new perspectives, new implications of grand design. The establishment of the standards essential procedure was a very interesting way in which the industry recognized that something significant was happening that had to be coped with and designed not by the judges who didn't have the experience and the perspective, and also who were deciding individual cases and therefore whose decisions were influenced by, of all things, equity and justice in a particular case. So that what's now needed, and this is why, not to repeat myself, why I think programs like this are so critical, because now what needs to be decided is what the law should be, not what it is because of the way it's evolved over the last few years in particular cases. And so as I see the various issues, for instance, that reach us in the standards essential area are heavily fact dependent, where maybe it isn't coming out quite right, or there's a new issue that wasn't foreseen, and therefore it turns on advocacy. Then we get judicial generalizations. Then we try and apply the generalization to the next set of facts, which differ significantly enough so that they need their own generalization. So I have quite convinced myself that it's time for a fresh start. We really need to understand the way business, the digital business, the cloud, the way technology is evolving, and the incredible power of this technology needs a look and understanding. The so-called patent troll was unheard of in the chemical business where I started. You had to run the experiment. You couldn't just sit down and draw a box with an arrow and all of a sudden have an earth-shaking advance for which you then exact tribute. So there is much to be thought of in the most profound way with the deepest understanding, building on the experience of the law and how things work under the law as it's evolved, but also to figure out what the law should be. It seems to me, and I think that Judge Michel put together really the most extraordinary and thoughtful compilation of the areas that are now up for grabs. The same old issues that we've always had, that when I started in this business, were settled. I just had to learn a few rules, and now have such profound implications for the practical evolution of the law and of the industry that we need to rethink from scratch. For instance, and I'll just close with this thought, I was always one who thought we should have one patent law that suits everything. It's basic, it's profound, it's objective. I'm not so sure. The software attributes, the way that technology evolves. I know on and off over the decades I've been in this practice, we would think about, should there be a working requirement in the United States? We don't need it. Of course we're going to work our inventions. And some sort of evolution in that development is something we should think about. Not that I think there's a quick fix for anything, but I do encourage us to think through this assemblage and those who are here today about where can the law take us, free our minds of the encumbrances of the past, and let's think about the public interest, where we want to end up, and how to get there.
Thank you, Your Honor. And I want to come back to some of what you said there. And if you are willing, and I know Judge Michel mentioned rethinking the unitary patent system, then I'm going to have to rethink my thoughts on that, because my thoughts have been so informed on that issue by the two of you in listening to your speeches on that topic have swayed me. So I'm going to have to open my mind again on that topic. But Kevin, I want to bring you in for a couple things. I want to give you a chance to react to everything that's been said, obviously, but I want to ask you a question that I won't ask the others, the judges, simply because, we've known each other for a long time, and it's no surprise to anybody who reads my stuff, and certainly around DC, everybody knows I'm a Republican. And I think, you and I, we talk politics, and we're on opposite sides of the aisle, and we're still friends, and we get heated, and I think I enjoy our conversations. One of the things that worries me, just recently I wrote yesterday, is the Biden transition team seems to have few advisors in our space, and the one advisor that they do have, it seems to maybe be a person who has direct ties going backwards towards some more restrictive policies. It's Colleen Chen, who's on record of being against the Stronger Patents Act and was, in favor of a lot of the patent troll narratives and those kinds of things. And it's not to say thoughts that are outside the mainstream. So I don't want people think I think that that's, wacky or anything. It's not wacky. I just think that I think it's time to, like Judge Newman was saying, move forward and look forward about the realities of today. So I'm afraid that, we may be looking backwards. Maybe I get your thoughts on that. And then anything else that you have heard that you want to react to.
Okay, well, I'm going to put that question last because I want to react and talk about some of the things that the judges talked about. We're the only two non-judges here, Gene.
Right.
I think that the thing about biotech and pharma that you have to think about that's different from standard essential patents, and that is the regulatory aspect. On top of it, Hatch-Waxman and the biosimilars law imposed statutorily this other factor. You can think about the 30-month stay almost as being a de facto injunction, because the moment that the innovator files suit, FDA will give them 30 months to prosecute the lawsuit and not give the generic the one thing they need, FDA approval. And similarly in the biosimilar space, you have various places in the statute where the reference product sponsor can get an injunction. It's been interesting because that's the part of the law that's much less well established than Hatch-Waxman, obviously, which was enacted 30 years earlier, and also some of the creative ways that the biosimilars people have had the court law have given us a little more uncertainty than I think that maybe the people who wrote the law intended, which brings us back. We've talked about whether Congress needs to get involved, and certainly there are places where that law probably needs to be tweaked, at least from the folks who were in the room. It's almost like back in the 100 or so years ago, the reason the Impressionists in Paris were so revolutionary was that they essentially were having as their final paintings the things that classically trained painters would do, and then they'd paint the final one on top of that. Well, the Impressionists were a lot less strict than that. Well, the same thing here. I think we have the instance where people thought that law would get a little bit tighter before it was enacted, and then it was enacted the way it is, and the courts and the participants, both the biosimilar and the reference product sponsor, have been reacting to it. It's just a little less certain. But that regulatory piece really changes in many ways how patents are enforced. certainly Hatch-Waxman, a very sort of well-established, strict regime where you do have they talk about the patent dance and biosimilar. It's the patent ballet in Hatch-Waxman, because it's very well established what will happen. And the injunction you get, if you will, if a prevailing innovator is that FDA will not grant regulatory approval. So that is a little less of a problem than we have, I think, in your space. But what I see as being, and Judge Babinski made me think this, was the coming challenge is how is the COVID crisis, if it continues, going to put the public interest into the biologic and drug regulatory vaccine sort of situation. How are we going to have the courts and the government react? We're talking about compulsory licenses. We don't really have those in this country, but in fact, you do have the prospect under the right or perhaps the wrong circumstances. You will have a possibility that public pressure and maybe some of the rhetoric that has come out over the past 15 or so years, both from the high-tech side and some folks, mostly academics, on the biotech pharma side, that the public interest would mandate that there would be a lot more government intervention, government intrusiveness into the way that patents, which if they're not, as Judge Michel said, a property right, if they're just a regulatory right, as came out of some of the Supreme Court language, does the government then have the right, because it is a government franchise, if you look at it that way, have the right then to regulate it in ways that people more traditionally thinking about patents didn't think you could. And it eliminates some of the worries about takings, for example. I remember there was a section of an earlier draft of the AIA that was pulled during consideration because it was recognized that if it had been enacted into law, at least one company on the banking side, the electronic banking side, would have something like a $4 billion bill they could present to the federal government for takings. Well, how does that impact the whole takings idea if it's just a government franchise that can be given and therefore taken at government whim? That's a concern. So I do think we're going to see that. And of course, without belaboring it, because I've been talking about this, as most of us have, for 6 or 8 years now, and there's whole sections of the biotech pharma practice, like diagnostics, that are just not even worth spending a lot of time on, because as I think Judge Moore said, don't bother coming to the Federal Circuit anymore. And in her opinion, Athena, it's done. Don't bother coming to us. These are not going to be patent eligible unless either the Supreme Court changes the law or Congress does. So when you have the patent court saying, basically gone fishing, right? Not here. It's not going to get you anywhere. It's a waste of time. And I think maybe it was Judge Michel who said there've been 50 cert petitions that have been rejected by the court. I mean, I see that there's no real future there, and unfortunately, not meaning to sound like the rebel in the group, but the sad thing is that if the Federal Circuit had decided some of those cases contrary to even what they thought the Supreme Court precedent was, maybe we would have focused the court to decide they had to go at least give us their further views. That could be a good thing or a bad thing, but at least there would have been not the sort of the stasis we're in now, where people are just not going to even try. And Judge Michel also talked about trade secret in his. It's going to be very hard to have trade secret, and not really in the public interest. I think that in the Myriad case, people were quite up in arms when probably right after everything started, Myriad stopped sharing the extra information it had gotten on informative mutations in those genes because it was being assailed in court. And all of a sudden you had a situation where Myriad, because it could keep those as a trade secret, was the better resource. And if you were a doctor, you were hoping if one of your patients had to get, I'll call them brand X, not Myriad, you were hoping they had a mutation we knew about, because then you knew what to do. But if it came back, well, no, we don't have a mutation in our database, you didn't have the entire database. So I mean, we've gotten these disconnects between patent law and the practical realities that I think cause difficulty. Now, to get to your question, because I think that it's a good question, I think that there's maybe a meme or a theory that Republican administrations look to business and Democratic administrations look to academia for these things. And I think about John Kennedy and some of the things he did that refutes that. But I would say that we have an opportunity, because we do have a new administration, to make sure that we make our views known to everybody who has President-elect Biden's ear. Now, you may not know that many people, James.
No, I don't. And that's why I raised the question, because one of the comments that I got on the article that published yesterday afternoon is that we really need to continue to raise this issue if we want to make a difference. And, and not to say that, I disagree with Colleen Chen and Mark Lemley on almost everything.
Almost everything.
Not everything, but on almost everything. But so who should the president be listening to? Because the first list of the transition team is not the last list of the transition team. These are the first people that are going to be giving advice. Who should we recommend that they be listening to? Who should be added to this list?
I mean, for intellectual property policy, people like Dave Kapos, for example. I think that Senator Coons is someone who, having just gotten reelected, as you mentioned, is someone who, first of all, he's from Delaware, and so he should know President-elect Biden. And
maybe Kevin.
Well, I mean, anytime President-elect Biden wants to call me, my line is always open.
Because they need somebody with life sciences, I think, because the life sciences community has really been raked over the coals.
Well, I agree with that. I think that Sherry Knowles, thank you. Sherry is another person. I remember, it's funny, Sherry and I were at a conference in fact, the week that President Trump was elected, and we were talking about the best way to get attention from him, and I don't think we did that as effectively as we'd like. But I do think that, and this may be self-interest, but I think that writing about this is the best thing we can do. Because it brings the issues at least into the public square, and I'm always surprised at people who call me up and say they read something that I wrote, and so I think that when you do what I do, that's the best way for us to get it out there.
Yeah, no, I agree, and that's why I wanted to raise it with you. So thank you for indulging me in a little political talk, which you can't seem to do anymore in America right now.
I think people get too uptight.
Yeah. So I want to go back to the or actually before we do that, Judge Michel, I know you're with us, and I want to give you the last word, since we were talking about your issue that you raised about holdout versus hold up. Would you like to comment on what our panel has said so far?
Yes, Gene, but just briefly, since I had the mic for so long with the keynote address, but just a couple quick points. First of all, it seems to me that enjoinability for proven infringement to block continued infringement goes to the heart of what a patent is and what its function in the economy is. And therefore, I suggest that mapping out the appropriate way forward should be a joint project, partly by the courts and partly by the Congress, with respect to the broadest outlines of enjoinability, because that involves national innovation policy at the highest, most consequential national level. It seems to me Congress has an important role, a primary role, and has to play it if we're going to have a healthy system. But that doesn't mean that judges and flexible analysis, as has been described by all the prior panelists, isn't part of the picture as well. And in advance of legislation, or even in the wake of legislation, I think judges can do a lot to tailor injunctions to the realities of a particular case. I would suggest that we should not assume that either all the infringing products should be enjoined or none should be enjoined. I don't think we should assume that the injunction must issue immediately upon judgment and be immediately enforceable versus never. because it is possible to tailor the scope of injunctions to fit the realities of the circumstance. For example, if replacing a component that caused the infringement would take 6 months, and meanwhile the existing inventory should be allowed to go forward, then a judge has the option, I think in all systems, but certainly in the common law systems, to delay the effective date of the injunction for 6 months. Or if in some products you really can't replace the infringing product, then maybe you have a different way of handling that. So I think it's a shared responsibility between the national legislature and the courts. But if we don't get injunctions right, the whole patent system, I think, teeters toward collapse, because incentivizing the needed investment is the key here. And I don't easily accept the idea that we can carve up the technologies and say, well, in the software space, in the internet space, in the computer space, lots of things can be done fast, and therefore you don't really need long-running patent rights, or maybe patent rights at all. Well, that's probably true. For some innovations in those spaces, patent rights are probably irrelevant. You'll get some innovation without patents. But I want all the innovation, not just some innovation. So in all the spaces, and I think it is true of all the technological spaces, where some innovation will require large investments, then you definitely need meaningful patent strength, where you're just not going to get the investment. And we already see in the United States, for example, and I'll end on this, that the proportion of venture capitalist money going to advance the science of chip design and production is now about 1/10 of what it was a decade ago. And it's, I think, attributable to the weakness of patents, particularly with regard to difficulty of getting injunctions. So this is something we really have to get right. The validity is important, eligibility is important, all the other things that have been mentioned by me or colleagues on the panel are important. But to me, the single most important thing is, what is the function of the patent? What does the right imply? How does that get deployed? And that turns first and foremost on enjoinability. That's what we absolutely have to get right.
Okay. All right. We got a number of questions, and a number of them actually relate to the same topic. I'm going to get to those here in 1 minute, but I want to go back to Lord Justice Floyd, because of something Judge Newman raised with the fresh start idea, because this was something that we talked during our prep call, and this was probably the one area where we had, I think, some disagreement or some thoughts that were we're not in alignment, I think, on this. And I think, Lord Justice, what you had said was that you couldn't necessarily see legislation wanting to start over from scratch. And I also, Judge Grabinski, I think you also mentioned that, a patent is a patent for all tech areas. So I'd like to get your ideas on that, starting with you, Lord Justice Floyd. Do you think we should entertain the idea of bifurcating the patent system? Because I think from our U.S. perspective, we have software on one end, which creates a whole mess of problems and maybe doesn't need as long or as strong as protection. That's what some people say. And then pharmaceuticals on the other end, where few patents for a drug and you need really strong protection. Your thoughts? You're on mute. There you go.
Thank you, and usual offence. Yes, should the patent system be one size fits all? Really, is the question. And in a sort of wonderful idealistic society, no doubt every patent should be tailored not just to the industry, but to the nature of the invention. So that a little invention could get a short patent, or a little patent, or a patent with limited scope, or patent with the right to injunctions cut off, and a different kind of invention could get a different sort of patent, and a really world-shattering invention should get the biggest patent of all. But in practical terms, I think, first of all, that is not pragmatic statement, but what you would create, I think Judge Michel said in our private discussion, would be, in every case, there'd be a tremendous fight about what the invention justified in terms of relief, or what this industry needs in terms of relief, and it doesn't work. We have, on the other hand, we have over the years found some specific instances which have justified a modification to the patent right. For example, the pharmaceutical invention in Europe can benefit from the supplementary protection certificate regulation, and get an extra bit tacked on the end of the patent because of the regulatory delay that Kevin spoke about, and so you get a bit of tailoring to the nature of the industry there. In the olden days, and as I approach retirement, I can speak of these things. There used to be a petition. You could petition the English court for an extension of the patent, and there were various criteria which you had to satisfy for your invention. It had to have been commercialized. It had to have been of outstanding benefit. And you can imagine the sort of fights that created, with people wanting to get on the market and resisting the extension, all of which, of course, adds to the costs of litigation. So very often in life, you just have to have one remedy for everybody. I remember when I was at school, if somebody committed an offence, the teachers didn't bother to find out who'd done it. They just kept the whole class in and gave everybody the same punishment. Maybe in the practical world, that's the right answer.
Oh, Gene,
I did the same thing.
Muted.
Yeah, I did the same thing. Sorry, Judge Grabinski, do you have some thoughts on that as well? I know during our call you had some thoughts, and in Germany things are somewhat different. I guess you have different patents that can be chosen, right, by the applicants.
Yes, we have different kinds of patents. We have utility models. Well, we have national and European patents, but the European patent is essentially like a national patent because it's a bundle of national patents in essence. But I like the idea that from the outset, the patent law should be the same with regard to all kinds of technologies. And certain principles of patent law should apply all the time. However, this doesn't mean that with regard to particular situations, patent law gets more tailored. That is not excluded by my starting point. You have the same set of law as a starting point, but then you tailor. Like Lord Justice Floyd mentioned, for example, in the pharmaceutical field, we have the supplementary protection certificates that prolongs the time of a patent for a couple of months. For example, we also have the Bowler exception at the other end, where you are allowed to make trials which normally would consider to be a patent infringement, but which are not, since they fall under the Bowler exception. We have a couple of things. For example, since what Kevin mentioned, he raised the issue of COVID-19. And this is a very special situation, a pandemic situation, and it looks like we're going to have a vaccine rather soon. For this kind of situation, the German patent law, for example, in a provision that I've never looked at before the pandemic situation came up, which is section 13, provides that in case the public welfare is at concern, the government can come in and declare that this particular patent can be used by everybody. That's possible. That's, of course, only under very restrictive circumstances, but and we never had this before. Because of this, I didn't know about this section, actually. I never came across this before, but it could become relevant, even though I do not think that in the current situation it will become relevant for different reasons.
Right.
So we have.
I think
maybe just. I think there. So they are a lot of. When you look closer to the patent law, you find a lot of provisions that apply to particular situations and that allow to tailor the patent law also with regard to different technologies. You only have to find them.
Yeah. Now, what about NPEs? I mean, that's a big question here in the U.S. and I suppose around the world. Why should patents be treated differently if they're in the hands of NPEs? That's a question from the audience, and because the way the question is phrased, it says R&D efforts still require a lot of money, and that is true. And there's a lot of times the NPE comes in and they'll buy the patents or they'll invest in the company fails, and now you're trying to monetize what's left over, or there's a whole host of different reasons why an NPE might wind up getting a patent. I see the argument in sometimes both ways. I personally think, and maybe we get your all reaction to this, if we had like under the eBay system, the fourth factor is the public interest. Now, in the U.S., I think the public interest becomes, well, the public is interested. You've got a technology that the public is interested in using, so therefore you patent owner lose. And that becomes like a one-factor test, and no amount of evidence on the first three factors can overcome the fourth factor on like any patent. And that to me is, I think, disingenuous. But if we actually looked at it in I think an honest way, and I think part of the problem is the Supreme Court doesn't take these cases, and I don't think the Federal Circuit gives enough guidance on what it means to really be, quote unquote, in the public interest, and what is not in the public interest. So I don't know that we have enough information out there, because I'm rambling and stuttering because I don't know what the answer is. I mean, does anybody know what the answer is? Other than just the platitudes that everybody throws around and say, because then it starts to get like a religious political discussion. Well, NPEs are bad. Well, NPEs solve a problem, and it's like, well, no, I mean, every case should be different. If you have a life-saving treatment to a pandemic, the public is very interested in that. If you have a solution that lets somebody listen to music a little bit more crisp, well, yeah, the public is interested in that, but you got to pay if you want to use that. I mean, that's not like life or death or anything. There's got to be a sliding scale on the public interest, it seems to me. And I don't think, at least in the U.S., there is.
If you allow me to weigh in.
Sure, go ahead.
That's probably not an aspect that will solve everything, but I think it's an aspect that matters. Let's make litigation more costly, more expensive, also for NPEs, for everybody, with regards to the principle of cost shift. When you look at the European situation, you have to think twice whether you bring a litigation for a patent infringement and the patent is no good, because at the end of the day, you will have to pay the cost, your own costs, but also reimburse the other parties for their costs. And I think that would help to at least make it less attractive to sue based on no good patents.
Gene, I have actually a question for the judge, the American judges on the panel. You probably talk to district court judges more than I do, or at least not as contentiously. And I wonder, we did have a shifting or maybe a lowering of the burden toward getting court costs and attorneys' fees from recent Supreme Court decisions. Has there been, looking at what Judge Grabinski said, has there been any evidence that you've seen that, in fact, that has changed behavior for people who are suing on their patents? Has it reduced, I won't say frivolous, but at least questionable, has reduced assertion of questionable patents in your view? Either Judge Michel or Judge Newman? Or have you heard tell of that?
Okay, can you hear me?
Yes.
Yes.
Well, I'm struck. I'm reminded in terms of how we find the answers, because these are questions that have to be answered. And I think back as to how, what some of you have heard me say this before, the glory days of when we, the major upheaval that ended in the formation of the Federal Circuit was handled by President Jimmy Carter, who pulled together, you may remember, he called it a domestic policy review of industrial innovation. And the members of that review were everyone who had an interest. Industry was very well represented. I was a member. The litigating bar, slightly represented. Don Dunner was a member. The Justice Department was represented. The Patent Office was represented. The economists, scholars, academics, to try and come together in one room. And I was thinking as I was listening to us, there were no judges on that review. And the reason the review determined was that we had a very simple solution. The judges were the problem, because the judges didn't understand what the rest of us knew. They didn't know how industry worked. They didn't understand that maybe you had to meet a payroll. They didn't understand all of the implications and interactions of licensing, of the interaction of federally supported research. For instance, one of the outcomes of that was the Bayh-Dole Act, which allowed federally supported research to be licensed exclusively rather than non-exclusively, because under the rule that the feds paid for it, it should be free to everybody. Nobody used it. Once it got to be entitled to an exclusive license, it started to be developed. As far as where the final decisions were being made, it was unanimous that they weren't coming out right through the judges, which was perfectly understandable, in part because, I said earlier, the judges were deciding specific cases with generalized rules that then didn't fit the next case, but even more so. And we didn't pull any punches. The judges didn't understand how industry and science and technology worked. They were in another world. That was the path that they took to being judges. So what I'd like to see, and some of you heard me say this, is that we do this again, finally pull together the leaders in the nation and in the world with all of the viewpoints and free our minds of the encumbrances of what we've built up and figure out where we need to go. I know we mentioned just a little while ago the example of the pharmaceutical industry, everyone says drugs are too expensive, but they don't stop to think that maybe the next cycle of drugs would be slowed down, or maybe not even pursued with the current state of the law. So the balance of all this is extraordinarily complex. And to come up with a law, an all-purpose law, or even a specialized law that fits all, is not easy. And that's what I think we need to do.
So let me ask you this. We have the most popular question that we've got so far from the audience that's been voted up the highest is, what is your view of arbitration and mediation as an alternative to high cost of IP litigation? Now, and that was raised by Your Honor, Grabinski, Judge Grabinski, as one of the issues, you know. And sometimes the high cost of litigation can be a deterrent and force people to settle. And sometimes it can just raise uncertainty, and sometimes it can allow the more dominant player to bully people around. Does anybody have thoughts one way or another about arbitration and mediation in the patent space or IP space in general?
Well, let me actually jump in on there, Gene, if you don't mind.
Jump in on that briefly to just suggest that under current American law, it's very problematic because to be effective, it has to be supported by both sides.
Right.
Admitted to by both sides. And there's a vast portion of cases where that agreement, that consent will never be forthcoming. So those cases are going to all end up in the court as the default mechanism to resolve the disputes. And I don't see that changing as long as some companies would prefer to litigate and get an early, cheaper resolution. Where both sides want an early, cheap resolution, fine, it works, they settle. But where one side or the other, or maybe even both, don't want an early or inexpensive resolution, then you're stuck with 6 years and $6 million, and it's a mess.
Yeah, I mean, I'm in favor of mediation, particularly. Arbitration comes with certain risks in that some people are afraid of. Some people like it, you know, for specifically for those same risks that others don't like it. But mediation, if you can get both parties to agree to it, it can certainly bring you closer. But in the U.S., what we've seen as a part of, as we were talking about earlier with the hold up versus hold out, those who are holding out have no interest in arbitration or mediation. And a part of their strategy is the war of attrition and to bleed the innovator to the point where they can't afford anymore to pursue litigation and they just have to fold. And then that goes into the second most popular question. Well, why should MPs be treated differently? Well, you know, because a lot of times these patents fall into the hands of the MPE because the original innovator has been strung out for so long they can't afford it anymore. You know, and now the MPE becomes a real force that has money and funding, and so it can be a mess. You know, does anybody have any thoughts on that whole?
Gene, I have a thought. Just from the perspective of,
and then we'll go to Justice Floyd.
Okay.
Go ahead, Kevin.
Okay. From the perspective of the pharma industry, anyway, the magistrate judges do a very good job of incentivizing litigants to settle, and are very active in it. And in fact, given the ability of usually there is some horse trading of the generic can come on the market, and a lot of that negotiation, when done without the magistrate judge's blessing, runs into accusations of antitrust issues or pay for delay issues, that sort of thing. And the magistrate judges can, by negotiating that with them, almost give them the blessing so that there's less risk the FTC is going to come knocking on your door and saying that somehow this was improper. So I think that there's a role that the magistrate judges have played in Hatch-Waxman litigation anyway, to try to facilitate sort of a reasonable and public interest benefited outcome where the generic drug actually gets to market faster than it would have been if the litigation had been ultimately resolved in favor of the innovator, and yet the innovator doesn't lose everything on losing a court case much earlier than their patents expire.
So it looks like we're out of time, but Justice Floyd, if you could very quickly give us your final thoughts, I'll give the final word to you.
Two very quick points. First of all, don't be too hard on NPEs, because one of the ways in which you can realize your investment in making the invention and in bringing it forward is by selling your patent. And if you make the market in selling patents too unattractive because the purchaser can't enforce them, then you close off that way of raising investment. So far as litigation, arbitration, mediation is concerned, I'm all for mediation because it gets rid of the case. But some people have to litigate in public. Otherwise, in a common law system, the rules don't get developed. And everybody benefits from the clarity that you get by having principles decided in the courts. Take, for example, the Supreme Court in Unwired Planet, which has now cleared up the way for people to resolve their FRAN disputes.
Well, thank you very much. And I think that was an excellent conversation. I know we went a couple minutes over. I apologize, Daryl. Wanted to get some of those questions in that were building up. And thank you, Justice Floyd, Judge Newman, Judge Grabinski, Kevin, and Judge Michel. Great conversation. Thank you.
Thank you.
On that panel and Gene for a great discussion. My name is Kyle Cirilla. I am the IP Law Fellow here at John Marshall's IP Center.